of my slides. So when the meeting is over, he'll be able to post it or distribute it or whatever in case you want to look at this later. So with multiple members who are going to be purchasing interest in the investment LLC, we do have to worry about whether we go into the world of securities. And it all comes because you don't have enough money to buy all the real estate you want to own by yourself. You're going to have to pool money with others. And this is the diagram that runs my business. This is how it all works. We have an investment LLC. It owns the property. When the bank comes to underwrite the loan, they're going to look at the property. They're going to look at NOI and debt service coverage ratio. The appraisal will happen up here. And then all the members, they invest up here. They invest their money. And because there are multiple members, we need a manager. The manager is going to make the decisions, have the authority. The manager receives some cash distribution and collects fees from investment LLC. And that's an important role. You really have to have that manager because there are too many members over here. You can't just vote to make all the decisions with a lot of people. So you need someone in charge. Somewhere along the line, you might be going to the lender, and the lender may say that, well, you know, you don't have enough net worth, you don't have enough credit to qualify for the loan, because the manager gets underwritten as the borrower. And typically the manager or the entity of the manager needs to have as much equity as the loan that you're qualifying for. So if we don't have enough of that, we may have to go out and find an enhancer. I call it an enhancer. Some people call it an angel, a sponsor, whatever. Key principle. All the same thing. So what's important about this diagram is this box right here. We've got multiple members. We need a manager. So follow this. We've got investors investing their money in a common enterprise. Ideally for the expectation of a profit. This is not GoFundMe, this is a business. And we're investing in that investment LLC because we think there's a profit potential. But it's all going to happen because the role the manager plays. An investment of money in a common enterprise with an expectation of profit, and the results are going to be because of the manager. This is a manager managed LLC, and by definition, it's a security. So welcome to the security world. Now I'm learning with my toy here. Okay. Why is it a security? Is because in some case called the Howey test, the Howey case in front of the Supreme Court, they defined what an investment contract is. The word investment contract was in the middle of this big long paragraph of what is a security, but no one knew what it was. So here comes a case having to do really with real estate. People were buying lots in an agricultural farm. The agricultural farm said, we'll raise the citrus, we'll harvest it, we'll sell it, we'll share the money with you and go forward. Well, the agricultural farm called Howey went out of business. And so Howey tried to collect on all the land contracts for all the small pieces of dirt that people bought. And some people said, well, you know, we really didn't buy the dirt. We bought the fact that we invested in Howey. Howey was going to run the business. Howey was going to make it happen. Howey was going to share the profits with us. And that's a security. So the court took that case and said, yes, went all the way to the Supreme Court because it was decided differently at different levels of court. And Howey said, well, if it's an investment of money in a common enterprise with an expectation of profits through the efforts of the promoter, and this is the number one part that makes our world and my business of security is we have the manager LLC. The manager LLC makes it all happen, has the authority to make the decision, and everyone is counting on the manager to make this investment work and to generate the profits that had been projected. So we start in the discussion with, is it a security? And if it's member managed, remember my first picture? There were just a single member or very few people. So that's a member managed LLC. If it's member managed, it's not a security. But if it's manager managed, it is. And so that takes us into the security world. And in the security world, we have a couple ways to go. We can go to the SEC. And there are a number of ways. When we go to the SEC, we'll have to get permission, we'll have to get a permit, we'll have to register it with the SEC, and it's very time-consuming and very expensive. Every security needs to be registered with the SEC unless it's exempt. And so the securities laws carved out offerings that are exempt from SEC regulation. They carved out a whole set of laws for that way back when they started, and they called it Regulation D. Now, this is where all of the business happens. So I'm telling the story about people coming to me. They want to raise a bunch of money. They want to manage it. They probably want to make some fees for it. So it is a security. So now we're going to say, okay, you're going to go to the SEC and do this, or you'll be exempt from the SEC and do it a simple way. Now we're in Regulation D. So we work all that way down to Regulation D. And Regulation D today, after the Jobs Act, really has two parts. This part over here, which is now called 506B, just used to be 506. When I was raising money, this is how we raised money. I could raise as much money as I wanted. I could have as many accredited investors as I wanted. And all I had to do was have them check a box because I knew them all. No advertising or soliciting. So no one got in there that I didn't know. So I would pretty much understand if you checked the box that you were accredited, whether you were telling the truth or not. And in addition to facilitate capital formation, they allowed 35 people who weren't accredited, but through their education and their training, we felt they could read the documents, understand the offering, and take on the risk. And we call those sophisticated investors. And the SEC regulated and constrained the amount of risk that each one of these offerings had, not by limiting the amount of money that was raised, because mostly everyone was accredited, but by limiting the people who weren't rich and smart, who weren't accredited, limiting that number to 35 sophisticated investors. And one of the rules on the to be an exempt offering comes out of Rule 502 that you have to disclose all the material facts. In a Regulation D offering, you have to do the disclosure. So we suggest, and sometimes it's absolutely required, that you put everything in writing, and we call that a private placement memorandum, and you've heard those words. Well, this was fine when I was raising money. The only problem that I had is I couldn't advertise or I couldn't solicit. So when it says I could have attracted unlimited accredited investors, well, unlimited to those I knew. And there's a lot of accredited investors, and I couldn't advertise, so I didn't know a lot of them. And then the accredited investors might have known me and a couple other sponsors, but they didn't know all the sponsors that were out there that all had great product. So in the Jobs Act 2013, 2012, and 2013 came along and said, what we need to do is we need to take another step forward in promoting capital formation, because Regulation D, private placements, is where all the money's raised to start all the small businesses in the United States, not just real estate, just all sorts of business. And so they came along with 506C, And the big issue in 506C is they allowed advertising and solicitation. So if I'd been raising money when this came along, I could have then gone out and advertised my offerings to everyone, really. I just could only sell to people that were accredited. And then all the accredited investors could reach out and find all the good sponsors like me to invest in. So 506C, it's no limit on the amount of money raised. I've done offerings up to almost $200 million. I've done offerings at $360,000. No limit on the amount raised. You can have as many rich and smart accredited investors. But since you don't know them, you have to take a third-party approach to being reasonably assured that they're accredited. And PPM is recommended, no sophisticated investors, and you can advertise and solicit. And I always get questions, what do you mean by that? It's anything you can do. Any way you can get the message out to people that you don't know, to tell them about your deal is okay. But in order to take them into your deal, you have to be reasonably assured that they are accredited. Now, before I get into the definition of accredited investment, I want to talk about how big this market is. The last statistics that the SEC put out, which was a 12-month study, and the 12-month study ended about 6 months ago, but in the 12-month study, it said that private placement market was $1.8 trillion, with a T, trillion. That's more than new money was raised on SEC public offerings during the same period of time. And 1.8 trillion, 90% of the 1.8 trillion was raised in Regulation D. 95% of the 90 was raised in 506B. Okay, so that's where you're going to do your business. You're going to do Regulation D, and we're going to decide if you're going to advertise or not. And so accredited investors, you probably already know this because this has been around for a while. Accredited investors are those which have a net worth in excess of $1 million, not counting their house, or have an annual income of $200,000, or if they're married, filing jointly, $300,000. And that's been the rule actually since 1981. And just recently, and you notice that rule is totally driven by dollar and cents. If you don't meet those two levels, you're not accredited. You might be sophisticated, that's fine, but we don't care. When you're accredited, we don't care if you're sophisticated. You're just rich and smart. We'll take your money. But in the last couple of years, the SEC has thought about maybe there are some people who, by their business work or their education, may not have the net worth or the income, but they're still capable of investing, and maybe we should call them accredited. So right now there's a set of rules that haven't been published yet. They've been agreed to by the SEC commissioners, but until they get published, and then 60 days after the publication, they become final, this is what they're going to add. First of all, they decided that anyone who sells securities for a living and is licensed selling securities, we don't need to know their net worth or their income. They just, by their business experience and education and background checks and all that, are accredited. Pretty good. And they say that's about 780,000 licensees. Now, I'm assuming most of them were accredited already, but this might help the newer people coming into the business. Then I think this is important. They added a term called spousal equivalency. Now, the $1 million net worth is assigned to a household. The $300,000 annual income was assigned to married couples filing jointly. What a spousal equivalency says is if you're living in a household, but you're not married, but you're living in the household, You can combine your net worths and you can combine your income to meet the goal. You don't have to be married, but you have to be living in a certain way so that it is a spousal equivalency, and you can read the regulations on that. Then we also added family offices, IRAs, and 401ks with $5 million of assets. There's always a question in a family office, which may have many, many people, young people, old people, who is accredited or who isn't accredited. We don't worry about that now. All we need to know is if the family office has net assets, or just plain assets, excuse me, of over $5 million, they are accredited. The same with an IRA and a 401k. We don't have to worry about who the owners are. It is accredited. And this one is pretty interesting. It says knowledgeable employees of the sponsor. Well, I once heard an SEC commissioner tell this story. They were faced with a lady who was working on Wall Street, and her job was to do the underwriting for a public real estate investment trust. She was a chief underwriter. She had $900,000 in the bank. She had no debt. She made $187,000 a year as a salary. She was not accredited according to the $1 million net worth and the $200,000 income level for a single person. She was not accredited. She could not invest in her company's deals, the deals that she underwrote. So they've changed that, and they've said knowledgeable employees of the sponsor will now be able to invest in the sponsor's deal regardless of whether they're accredited or not. And that won't affect too many people, but the people who are working, all my clients have employees who work for them and do certain things, and if they're knowledgeable, now they can be considered accredited and can invest in their company's own deals. So where is that going to take us? Right now, it looks like there are 16 million families, households in the United States that are accredited. That's a lot of investors. That's an awful lot of investors. That's 13% of all the households. And so if you want to do 506C, you can advertise. There's a whole pool of investors out there to advertise. This is where some of the crowdfunding platforms go. You've heard of Real Crowd, you've heard of CrowdStreet, Realty Mogul. In their effort to do 506Cs, what their job is to build an internal database in their platform of as many of these accredited investors as they can find. And some of the more progressive crowdfunding platforms have upward to 40,000 accredited investors already approved in their database. So if you could have a property and you could take it to them and have them market it for you, you'd have a huge market. And that's kind of a topic for another session. Now, getting down to the end of this, I want to have something for those of you who aren't sponsors, who are investors. And I guess if you're a sponsor, you should also listen to this, because these are 4 questions I absolutely think a passive investor, one of the members who's not going to make any decisions, should ask. And the first question you should ask, you should say, Gene, what happens if something happens to you? I'm going to invest my $50,000. You're in charge. What happens if something happens to you? Well, that's a very interesting question, and it all goes to continuity, and it goes to the protection of the investment and the investor's money. So when people come to me and want to do a syndication, and I ask them, who are you going to have in your manager LLC? And they say, just me. I go through my sermon and I tell them I don't think that's a good idea. And if I convince them, we come up with a second or third person, put it together, and away we go. If I don't convince them, I don't take them as a client because I don't think it's right. I have been a replacement general partner, managing member 7 times in my career, where there's only been one person in charge. one person died, but there's all sorts of other reasons that the person in charge can't continue. And it's a disaster for the investor. So we need at least 2 people in the manager LLC. The next question I would suggest that the passive asks, has the sponsor done this before? Do you have a track record? Well, all of us have had to answer that question no at some time at the beginning. No, I've never done this before. This is my first deal. So it's real important to get your first deal out of the way so you don't have to answer that. The next time someone asks you, have you done this before? You say, hell yes, once. But you've got to get past the first one. Next question, will the sponsor have skin in the game? And when I say that, you're all thinking, well, that makes sense. The sponsor should invest money. Well, that's true. And that's the way it was when I was syndicating. That was the way to judge if the sponsor had skin in the game. But today it's more than that, because today the sponsors are being asked to sign the mortgages. So putting your signature on the mortgage, whether it's recourse, not recourse is making a difference. That's a value to the entity. That's an investment you're making to the entity. So that, in connection with the amount of cash you put in there, is something that you can say to the investor, yes, I do have skin in the game. And the last one, the investor is going to say, well, Gene, what happens if I need my money back? I know you've got continuity. I've known you've done this before, and I know you have skin in the game. But I'm 72 years old, Gene. What happens if I need my money, my family needs my money? Well, the sponsor is going to be able to say, you know, we have professionals who draft our operating agreements. And our operating agreements are very complete and concise about a plan for liquidity, whether it's voluntary liquidity or involuntary liquidity. And I know in our documents, it's Articles 11 and 12, and it's 5 or 6 pages of language of what happens when an investor needs their money. So those are 4 really good questions. And you'll notice none of them have to do with the NOI. None of them have to do with IRR. Okay? This business is much more about the people than it is about the real estate. We all know, all of us who are listening to this call are well educated on how to do due diligence in real estate. We all know that. What's new about being a syndicator is that it's a people business. You're all of a sudden you're taking in 15, 20, 25 people in every offering. You do 3 or 4, you've got 100 investors. Wow. That's totally different than being a broker. They sign the papers, they take occupancy of the property you're leasing to them, you get your commission, and it's over. They sign the papers, they close on the deal, they buy the property, it's over. As a sponsor in this business, at least the investors think you have their money for the whole duration of the investment. And that can create very interesting conversations between you and the investors. What's happening with COVID? We do have some decreased rent collections that we're seeing, and you probably know this in your daily practice. And it depends upon what product you're talking about, retail, office, multifamily. A lot of syndications are multifamily, and the multifamily business nationwide is still doing pretty well with rent collections. Yes, there are going to be some mortgage delinquencies, and there are going to be some requests for forbearance. You have to understand, how does that work for you inside of your offering documents? And in our offering documents, we're always looking at the possibility that the company is going to need more money than they have at some time. So we write it so in this order, maybe the manager can make an advance or make a loan to the company. And if that doesn't happen, maybe there are certain members who can make loans or advances to the company, and we write about those rules. If neither of those things happen and we can't find third-party money, we absolutely have to go to the last and the least successful of all, is to make a capital call. And once again, that should all be written out in a well-drafted operating agreement. How does the capital call process work? And because people think there are going to be mortgage delinquencies and blood on the streets, I do have experienced clients coming to me and say, is it time to do a blind pool? Is it time to raise a bunch of money? This is just an acquisition strategy. Raise a bunch of money so when properties get in trouble, I can go out and bid on them. I can prove funds. I can compete with the 1031 investors. I can go to the bank and buy properties. There's always been a rush to blind pools. I've been in this business really since '78, so I know about the two crashes in the '80s, the two crashes in the '90s, and what happened in 2008. There's always been a rush to blind pools. My issue is you don't really know when the bottom of the market happens. And my advice to people today is we don't know where the bottom of the market is. We don't even know if there's going to be blood in the street. So my advice to my experienced syndicators who are talking about this is we might want to wait a little bit. Now, new syndicators who want to come to the market and start with a blind pool, absolutely not. If you don't have a track record of successful offerings in the product type you're thinking of doing, you won't be able to raise any money in the marketplace for your blind pool. So that's it. Now, Helen or Shane, who's going to deal with the questions? You want me to go in the chat? Hi, Shane. How are you?
Hi, Gene. I'm doing well. Thank you very much. This presentation is amazing. And we'll now go into the Q&A session. To all our audience, please start asking your questions now in the Q&A box, and we'll ask Gene. This is an amazing opportunity to tap into Gene's wealth of knowledge and experience. And Gene, I'll lead off with the first question.
Okay.
For our members who are thinking about getting into the syndication crowdfunding game and are kind of intimidated by some of the first steps, where would you recommend or what would you recommend is the best course of action to obtain templates or how to draw up operating agreements for the LLCs in the property LLC, the manager LLC, and for the PPMs?
Okay, well, first of all, you don't do that. That's the practice of law. So first of all, you hire an attorney that does that. So that the first step is find an attorney on your team. I was talking, or I mentioned the fact that I'm going through this series of interviews that we're playing on YouTube called TLG Talks. And when I interview syndicators, I ask them, what's your advice for rookies? Okay, which is what you're asking about. And without exception, the 16 people I've interviewed who are syndicators have all said, you've got to have a team. You can't do this yourself. So one of the things you have to do with the team is go out and research, find, and attract a lawyer and a CPA who can help you through all this stuff. Now, that's really a good answer. But you've given me a chance to pitch something that I thought I had on this slide, which I don't, is that we're having a rookie camp. We have every month, we have rookie camps. It's a virtual class. It's 2 3-hour sessions. It's always on Wednesday and Friday. And we do one a month. And it is only for rookies. It's virtual, and we only take 15 people. So you get all your questions answered. Everyone's on the screen all the time, got their mics open and all that stuff. And we have a rookie class. There's more information on that at my website, TrowbridgeLawGroup.com. Of course, you could read my book, and a number of the people in your group who are watching today have read my book, and that's helpful. But I think this 6-hour class is pretty strong. I do a class like this for the Institute at the Ward Center 4 times a year, but those are 2 90-minute classes, and this is much more in depth, and I kind of control who comes in it by just having rookies come. And I think that's beneficial. How's that?
Wonderful. Thank you so much, Gene.
Okay, Shane.
And, we have a question from the audience from Steve. He asks, at what stage of the escrow should a sponsor begin raising capital via PPM for a specific offering? Would that be after the due diligence period?
Here's what most of my clients do. Most of my clients come to me when they have the letter of intent formed and signed, and they're expecting that the purchase and sale agreement will follow. And they hire me and we get started, because it's going to take an attorney 3 to 4 weeks. 3 weeks if it's a repeat client who's seen all the documents, 4 weeks if it's your first time with these new documents, for us to draft, edit, finalize, and get the information from your due diligence and from the lender on what the offering really is. So we'd like everything to come together, your due diligence period, your financing period, and the documents to come together at the same time, so that you have about 30 days actually to collect money. If you're doing 506B, you're always talking to the people with whom you already have a relationship, your pre-existing relationship, your clients. You're telling them, hey, here's a picture. This is the one we're going to do. We're not ready yet. Keep your money liquid. Find where your checkbook is, because I'm going to come to you in a couple of weeks and I'm going to ask you to invest. You don't want to take any money from anyone until you have all of your documents and you have your subscription agreement that they sign and give you their money. Now, in order to make that palatable for syndicators, our firm always puts in the fee agreement that you're going to pay me and I'm going to do the work. And if this deal falls through, you've already paid, I've already got most of the work done. We'll just go on to the next deal. Okay, so you don't have a risk. I mean, there's a risk that you never find another deal, I guess, but we don't have a risk of really getting started too soon. And if you're going to look at another attorney other than our firm, you're going to ask them actually if that is what they do for you.
Perfect. Thank you, Gene. Next question from Jesse. I'm working on getting my Series 22 license. Will I be considered an accredited investor under the new rules?
The answer is no. The new rule is specific, Series 7, 65, and 82, specific. That doesn't mean Series 22 won't be added later, because one of the things you do with Series 22 is you only invest in direct participation, private placement offerings, which is what all Reg D is. So it would make sense. But at the current time, the answer is no. Now, I would give a caveat to that question. When you get your Series 22, and I'm going to relay it to the real estate brokerage hierarchy, when you're a licensee, you can go out and get a listing, you bring the listing in, you take it into the broker, and the broker signs off and approves the listing. Okay. The securities world is totally different. If I have an offering, like I did because I raised all my money through the securities world, I would take my product and I would go to the broker, the securities broker. The securities broker would then do due diligence on my offering and decide if it's something that the salespeople can sell. Then the securities broker and I would sign a selling agreement. The securities broker would notify their reps that they now had a product that they could sell. So what I'm concerned about is I'm concerned about getting a securities license if, in fact, you think you're going to be your own sponsor. If you're just going to sell products of other people, that's fine. That's a great life, being a securities rep and selling other people's offerings. But if you're going to bring your own offering out, you're trapped, because now you're licensed with someone who has the ability to say, well, no, we're not going to sign a selling agreement, and we're not going to allow people in our company to sell your offering. So you might want to have a discussion with your broker before you go too far on this. That whole concept is called selling away. You can't sell away from the selling agreements that your securities broker has.
Thank you. Steve has another question. Once the property is successfully acquired, what are reasonable reporting periods? Every month or every quarter?
I think the issue is what's going on with the property. Okay, I built storage facilities. Every month, I like to send a picture to my investors to show them the progress of construction. And we were only in the construction business. We were in the construction business until the property got about 50% occupied. We were not in the operations business, and then we sold it to someone else. The someone else who bought the property, probably because all they're doing now is operating, could get by with quarterly reports. I would say 9 out of 10 of the offering documents I write when we talk about the plan for communication does talk about quarterly reports. And in all honesty, if you start out with monthly and you say, I'm going to have a Zoom call every month with all the investors, after about 4 or 5 months, no one shows up anyhow. So quarterly is just fine. If you're going to send out checks, clearly quarterly is enough, because the checks monthly aren't big enough for anyone to pay any attention to it. So quarterly is fine. And then you have the annual at the end of the year with the K-1 and the financial statement and whatever you think you're going to do about the tax return. So quarterly would be fine.
Thank you, Gene. Bob asked, Gene, what is your best guess for the SEC publishing their new regulations? And once published, will it be at least 60 days until in effect?
Right. My best guess was September 30th, and I missed. So my best guess, it's going to be this month. It's going to be sometime in October, because it's all done. They just need to publish it. And unless I missed it yesterday, it could be any day now. So I would say, and this is what we're doing in our company, the offering documents we're writing right now do not go into any details on the change in the accredited investor rules. And our clients are fine with that, because they're fine with the accredited investor rules really as they are. And for example, my number one client, as far as being prolific, has done 114 offerings with me in the last 6 years. They do all 506B offerings, only accredited investors, and they don't even take new investors into their investor pool anymore. They don't need new investors. And when I said that 90% of the 1.8 trillion is 506B, most of that is because most experienced syndicators have all the investors they need. And all the accredited investors who are used to investing in 506B know that all they have to do is check the box. We're not going to go back to a group of investors that have invested with us many times and tell them that they now have to go through a third-party verification to prove that they're accredited and look at their tax returns and all that. That's not going to happen. In our practice, the people who are going 506 are usually in the experience scale, I'm going to say more inexperienced than heavily experienced. And they really need the period of time where they can invest, where they can advertise this offering so they can build up their database. They can only take the investors who come to them who are accredited, that's fine. But being able to advertise for 3 or 4 months and put it on social media and all that stuff, and then getting people, putting them in your database and saying you can't invest in this deal because you're not accredited, but let's get to know each other. And 6 months from now, I'm going to come out with a 506B, which will let me take 35 sophisticated investors. It's a good strategy. I had a client last year who did an offering that was only $400,000. He knew where all the investors were, but he advertised for 3 months, just to build his database. And that's a fine strategy. And doesn't cost any more from the legal standpoint to have a 506C than a 506B, and you're going to do all your advertising, social media, so it's not any heavy burden, but it is a strategy.
Great. And Chris asks, he was looking for the TLG talks that Gene mentioned at the beginning and came back to at the end. So I believe Chris is asking, where can he find the TLG talks?
YouTube. Our YouTube channel, Trowbridge Law. And we're working on updating our website. So at some time it'll just be on the website. You can click and get right to it. This week, and it always runs at noon on Thursday, noon Pacific time on Thursday, I'm interviewing Kenny Wolf. Kenny Wolf is a syndicator out of Texas who's done 23 deals with me. And he came from the engineering world. And then he and his wife decided to buy some small properties. And then they decided that sitting around the kitchen table where all the great decisions in life are made, they decided that they'd go for something bigger. And so he picked a 73 unit apartment, and he didn't have enough money for that. So all of a sudden he found himself as a syndicator. And I know I did that first deal. First deals are not easy to do, but we did that first deal. So that'll be interesting. Last week we interviewed Vinny Chopra. Many people in this space know Vinny Smile Chopra, who I started out with and is now into really assisted living. And then I started out with Jim Hopper at AMC, and those two are on our YouTube channel. Hopper is the one who's done 114 offerings in the last 6 years with me. Very interesting story on how he got there and what type of offerings he does.
And Gene, it's now 11:01, so we're just over time. We have 2 more questions. Do you have time to answer these?
Sure, happy to.
Okay, thank you. Steve asks, last question, upon the disposition of the property, if investors are satisfied and want to go on to the next deal with you, but some investors want to cash out, is there a way we can do a 1031 exchange with the partnership?
Yes. The LLC owns the property, right? So the LLC has the deed. Now what we need to do is we need to take the equity that's attached to that deed and move it into another deed. Like kind, 1031, perfect. The problem is some of the equity wants to go away, like me. If we're in a successful syndication today and you're telling me you'd like to exchange into another one with a 10-year holding period, I'm probably not your investor. So what you do, and this is the advice I've been given by many accommodators, what you do is when you set up your escrow to sell the property you have, you really define 2 escrow accounts. One escrow account is going to be for the money that's going to be paid out to the Gene Trowbridges who don't want to go with you. And the other escrow is going to be the money that's going to go to the accommodator. Okay? And then when the deal closes, if you would, the checks are cut to the correct escrows, and the money that goes with the accommodator is now equity that can go into the new deed, and the money that goes to other investors, well, I get my money and it's taxable. That's fine. The only issue you have is you have to go up in value, right? Or equal and up in value, equal and up in mortgage. So if too much equity goes away, you may have some problems completing that exchange and having total tax deferral. There might be some boot. Now, I guess another question for Steve is, do you have the authority to do that? You need to look at your operating agreement. Most experienced syndicators keep the authority to do a sale and a refinance for themselves, but have a vote on an exchange. And the reason you have a vote on the exchange is so you can identify the Gene Trowbridges who don't want to go with you. that's one of the way to identify them. But it's really a new offering. When you have people's money in a deal for 5 or 6 years, and now you're going to take it into a new deal for another 5 or 6 years, I think in the securities world, that's a new offering. You have to give people the authority to make their own decision on whether their money is going with you. It's a different property. It's a different layout. I think it's a new decision. And so I'd give them a PPM, and I'd give them a subscription agreement. The operating agreement is going to be the same, but I'd give them a full disclosure of what they're getting into.
And thanks, Gene. And Steve says, thanks, Gene, as always. Very, very helpful info. And last question from Chris. What do legal fees typically cost for an offering? And should a sponsor or promoter have some sort of licensing?
Okay. In the universe of legal fees, okay, I'm going to say there are 2 types of attorneys. There are 2 types of law firms. There are the law firms that have offices all over the country and have 57 names down the side of partners. I'm not going to talk about that because none of the people who are listening to that need a law firm like that. That would be if you're going to Wall Street, okay? But in the smaller regional boutique type of law firms, I would suggest that if you planned on $15,000 for an offering, if you had that in your mind when you are interviewing attorneys and you heard their price quote, you wouldn't be surprised. You may very well get it less than that. Not too often will it be more than that. And generally you have to pay for that up front, but then in the offering, we have all the investors' money is raised, and then you get reimbursed for that. The second question was what was the second question?
Should a sponsor or promoter have some sort of licensing?
No, for the same reason that I told the other person who was working toward their Series 22, if you have a license, you may not be able to sell your own product. But it's even broader than that. You know, in real estate, for sale by owner says that you can sell your own property without a real estate license. You just can't sell anyone else's. The same rule applies in the securities world. It's called the issuer exemption. The rule is you have to be licensed to sell a security. The exception is if you're the issuer. So anyone in the manager LLC is going to be an issuer. They can sell the securities that are attached to investment LLC without having a license. They can't get paid a commission. That's another topic. But they can sell their own securities under the issuer exemption, but no one else's. That's it.
That's it. Hey, Gene, thank you so much. This has been just an unbelievably informative session. All of our members really appreciate this. On behalf of NorCalCCIM, we really want to thank you for coming on, sharing your time and expertise with us. This has been a real pleasure for us. And
well, I appreciate that. And don't forget to go to the website and look at the class for rookies. And congratulations on the new baby.
Oh, thank you very much. Yeah.
who didn't make any noise at all. So mama must have taken him or her away, right?
They're in the park.
They're in the park. Okay, that's great. Well, once again, thanks to the whole Northern California chapter and all your leadership in inviting me. And I'm a friend of the chapter, and reach out to me anytime I can help you.
Wonderful. Thank you so much, Gene. To all our members again, please look at on the screen here. Gene has all of his contact information. I highly recommend writing that down and contacting him should you have any future syndication, crowdfunding, or other general real estate attorney needs. Again, Gene, thank you so much. And to sign off, I'd also like to say, please join us this Thursday, October 15th from 10 to 11 a.m. for our mentoring session by our sponsor, Chicago Deferred Exchange Corp. with Teresa Flugel. And again, Gene, thank you so much and have a great day, everyone.